Good morning, everybody. Thank you all for joining us. I keep getting all these pop-ups at the beginning of our Q&A for all the different things that we're enabling, but all right, there we go. I'm just less distracted now. All right, well, thank you all for joining us today. I am going to start like I usually do with some Zoom housekeeping tips and sort of disclaimers, I guess we might call them. The first is just to let you know that if you could please stay muted during the Zoom today, unless you want to unmute yourself to ask a question, that would be great. Just cuts down on background noise and makes it easier for everybody to hear. As I did say, if you would like to unmute yourself to ask a question while we're talking, you're more than welcome to do that. Just remember to put yourself back on mute when you're done. If you are wondering where your mute and unmute button is, it's on your Zoom toolbar, which is probably at the bottom of your screen, depending on what kind of device you're using. That's also where you're going to find your start and stop video button. So if you want us to be able to see you today, please feel free to keep your video on. If you need privacy or you're working in the background, you're more than welcome to keep the video off. Just do whatever works for you. That is also where you're going to find the chat button, which you can use to submit questions during the Q&A. I did put a message into the chat just now, so it might be flashing for you. And the message just reminds everybody that A, you can put questions into the chat. B, if we don't get to your questions today, or if you have a question that comes up during the week that you would like us to cover next week, you can send it to info@condolaw.net by 4 p.m. on Monday afternoon. That gives us a little time to research and prep for including that topic in our Q&A next Wednesday. Also, if you submit a question and you're not able to attend, or you just have a particular topic that you want to dig into a little bit more, or you just like seeing the Q&A every week and you missed it last week, the link in the chat to our YouTube channel is where you would go to find all of the Q&A videos since we started doing this 4 years ago. So that link, with the exception of last week's video, because I'm late getting that up, which I'll get that up today when I put up the one for today as well. That link you can use to see all of our previous Q&A videos. And when you're in our YouTube channel, you can search within our channel only for a particular topic. And so if you search a really common topic like assessments, for example, you might get too many hits for the search to be really useful to you. But if you do a more narrow search like resolution or audit, you might get a smaller subset of results that are actually relevant to whatever topic you're trying to research. And so don't get confused between the general YouTube search bar and the search bar for our channel, which is a little bit further down when you're looking at it on the webpage. As we remind you guys every week, I want to remind you again today that we are not here to give legal advice. We are here to speak generally about legal topics that we think are widely helpful and of interest to community associations in Washington State. And we can't give legal advice in this forum. Even if you're our client, we can't give legal advice in this forum. And if you are a community that does not yet have an association attorney, I'm here to also encourage you to consider getting one now when you don't actually need one, so that you're not forced to scramble and hire an attorney when you're in a crisis, if you ever get to that point. But that type of attorney is the only person that can actually give you legal advice once there's an attorney-client relationship established, and also they need to be familiar with your particular governing documents and statutes. And you'll hear us remind you of that a lot when we're talking about the specific questions that we answer, because a lot of times folks submit questions that seem pretty general, but still rely on the governing documents for a specific answer to any particular community. So please just keep that in mind. Also, keep in mind that the chat, as I mentioned, is for submitting questions during the Zoom or asking us to clarify things, not for commentary or argument like you might see on the CAI message boards online. I do want to let you all know that we only had, I think, 6 questions that were submitted to us in advance for this week. So we are definitely going to have time to answer questions that you might put into the chat. So if you have something that you've been thinking about asking, but you weren't sure whether we would have time today, I'm here to tell you we will have time. So feel free to pop that into the chat. And if we don't get additional questions from the chat, we'll just end a little bit early today, which also wouldn't be a bad thing. We have been reminding you each week about the status of the legislative session, which, believe it or not, is almost over. So right now, a couple weeks ago was the House of Origin cutoff. This coming Friday is the deadline for any bills that are currently under consideration in either chamber to be voted on in that chamber. And then the actual official end of the legislative session is next Thursday, which is March 7th. You can watch the upcoming issues of the WSCAI Journal for a legislative recap for everything that went on this legislative session. But one thing that I can tell you is that the WUCIOA for All bill is still alive. It has passed the Senate, which was its House of Origin. It's currently in the House, and we believe that they will be voting to pass it. That's what I believe. I think it's going to pass. And I think that vote is likely to take place by Friday of this week. So I just put into the chat a link to what you'll see. It says ESSB 5796. That means engrossed Senate substitute bill. That's just the terminology that the legislature uses. And you can go to the link that I put in the chat and read the bill as it currently stands. There's a question in the chat about when it will become effective. That is the good news here. It is, they have increased the lead time between now and when the bill will take effect for all pre-existing communities in Washington state. And it's not until January 1st of 2029, I think. I'd have to double check that. It might be 2028. Originally, they were going to make it effective January 1st of 2026. But they got a lot of sort of pushback, and it became really clear that there was a lot of confusion and panic around what this bill was going to force communities to do in the way of things like amending their governing documents, for example. So they extended the effective date, and it will no longer take effect until January 1st of 2028. Thank you, Cam, for confirming that in the chat. So January 1st of 2028. So there's a lot of questions floating around about the bill. There have been a lot of changes to the bill. And one of the things that our Legislative Action Committee wants to remind everybody about is that even if there are pieces of the bill that are not ideal as it passes now, we have several legislative sessions between now and the effective date where we can continue to work with the legislature and hopefully sort of fine tune any sections that are not ideal and hopefully address those issues before the effective date in 2028. Another thing that I am hearing a lot of people assume is that they're going to have to completely restate all of their governing documents once this statute takes effect. And I don't think that that is the case. For the most part, the statute will just trump your governing documents if there's a conflict between the two. If that isn't the case, the statute will make it clear that the governing documents control versus the statute. Some communities will choose to redo their governing documents anyways, just because it will lessen confusion within your membership if your documents are actually consistent with the governing statutes. But not everybody's going to have to go out and spend $10,000 on a restatement just because of this new statute. And so I want to sort of assuage folks' concerns in that regard. The other thing that I want to tell everybody about is the annual conference for WSCAI, which is coming up. And I just put a link to that event in the chat. This is the first year that WSCAI is hosting this particular event, and it is a combination of what used to be, I think, Managers Only Day and Law Day. And essentially what happened with both of those events is that they both got large, and we outgrew, for example, Law Day outgrew the Linwood Convention Center, which is a really great thing. Our attendance was fantastic, and the space could no longer serve our needs for Law Day. So the WSCAI has combined those two events. It's now a weekend-long event. I think the weekend is April 19th, and it's happening at the Sheraton Grand in Seattle. And it starts on Friday evening and ends on Sunday around lunchtime, if I'm remembering correctly. And it's going to be a great opportunity for lots of different educational components, both of a legal nature and specific to managers as well. So if you haven't already registered, or you're still on the fence about whether you might attend the conference, I would encourage you to do so. We are going to definitely be there and hope to see you guys there as well. So those are all my announcements for the day. I'm going to jump into the questions that were submitted to us in advance. And then, as I said, we will definitely have time for additional questions from the chat once we get through these. So here's our first question. We are governed under the Homeowners Association Act 6438. We generally hold our annual membership meeting in March, and at that time we vote on whether to waive the annual audit. At this year's March meeting, should we be voting on whether to waive the audit for the year just completed or the current year? In the past, the vote has always been regarding the year just completed. The short answer to your question is that you've been doing it right. Each year when you vote on whether to waive the audit, and this is a requirement that you actually vote every year. You can't just vote once and then forevermore never have an audit again. You need to be voting on whether to waive the audit for the most recently completed fiscal year. There's no way to waive an audit for the current year because you just don't have the information that you need to make that decision from an informed perspective. We think it's very clear that the legislative intent is that you can only waive the audit for the preceding year. And at that point, as a practical matter, it makes sense because you'll have either your treasurer's or manager's fiscal report in hand, and having reviewed that report, then the members can vote to waive the required CPA audit. The flip side of that coin is that your membership cannot make an informed decision about whether to waive the audit without seeing the financial reports for the fiscal year in question. This does mean, so in the particular example given, that the budget your community adopted for 2024 should have included in the budget the fee for performing the 2023 audit, because you couldn't have predicted when you were putting together the 2024 budget that you were going to waive the 2023 audit. That being said, if you did not include that budget item in the 2024 budget, and if your vote to waive the audit fails, then you do the audit anyways. You just treat it as an unbudgeted expense. So I think that answers the question. Jennifer, if you have any comments, please feel free to add them.
Just briefly, the legislature put the audit requirement in 6434, but made that applicable to old act condos. It's also in, as you said, in 6438. The site for that particular statute in 6438 is 6438-054 sub 2. And it states that the audit must be waived by 67% of all owners at a meeting with quorum. Excuse me. So if you are, if your meeting does not have 67% of the owners, you're required to do the audit. If your meeting doesn't reach quorum, you're required to do the audit. I know this is an expense that many of our association clients choose to not engage in, but it's one of those financial checks and balances that the legislature is very intent on making sure happen. Also, just as a general rule of thumb, we recommend to our clients that audits be done every 3 or 4 years, even if you're properly waiving them every year, just as a checkup and making sure things are being done properly. Moving on to the next question. Maybe you've covered this before, how to write a simple resolution, what has to be included and what's not necessary. So there are a couple different ways to term resolution. So if you're talking about a paper resolution or formal resolution to, say, adopt some sort of policy, excuse me, those are themselves don't have any legal authority. It's just a reflection of the action taken by the board. I know Ken did a Google search right before this meeting and came up with 5 or 6 different resources for sample resolutions. CAI, the board, what was it, Valerie? The board member toolbox or something like that?
Yeah, I think if you just do a Google search for CAI online board resolutions, it'll take you to a number of different results from the CAI national website. So
many of these resolutions have language that is extremely formal, has very flowery language, wherefore, whereas, though that language isn't necessary. It's not a magic spell that has to be repeated perfectly to make sure it works. So brass tacks, a board resolution is any action by the board. If you're wanting to make a formal notice to the owners that the board is taking a particular action, you can do that in a document. So an example could be use of all fireworks is prohibited within the community, both in common areas and within the lots. Fireworks includes all forms of sparklers, smoke snakes, firecrackers, rockets, other devices used for celebration or other purposes, even if they're legal within the city or county. Fireworks present significant risk of fire and disturbance of neighbors' peace and quiet and cause stress for people and animals. This resolution will be effective immediately, being the date of its adoption, February 27th, 2024. Notice of this resolution shall be adopted into the association rules and provided as notice to all owners as provided by statute. So kind of bringing all that in, you have the formal action taken, the reasoning behind the action taken, when the action is effective, and how notice is being provided. Then, if you're doing this separately instead of just part of your regular board meeting minutes, that particular format will be sent to all owners as notice. So any formal action by the board that is going to be enforced against owners must have formal notice. Notice is given as described in statute, and the legislature changed how notice is given back in 2021, I believe. So that's just kind of in a nutshell. A formal resolution, how most people term it to be, is just any action taken by the board. This is the reasoning behind that decision, what the decision is, what action is going to be taken, when it is effective, and how notice is to the owners is going to be given. Valerie, did you have anything to add to that?
The only thing that I would add is when we were talking about this ahead of time with Ken, we were talking about the distinction between a resolution that, as Jennifer said, is going to be enforced against the ownership, which you would then need to send out to the ownership before it could be enforced, versus a resolution for some sort of internal procedure or process that the board is going to comply with or use internally. That type of resolution wouldn't necessarily need to be published to your ownership because it's not something that's going to be enforced against them. And then the only other thing that I was going to say is I don't want anybody to be confused and think that now every time the board takes a certain action or makes a decision, you have to have a paper resolution in addition to just recording that action in the board meeting minutes. You don't. So if you have been doing business as a community without using a single resolution in the whole history of your community association, and you are taking proper board meeting minutes that record all of the votes or actions taken by the board, then you're fine. You're just fine. The only time that you need a paper resolution that's separate from your board meeting minutes is if there is something that's going to be enforced against the owners, and then you want something in a format to be published to them, or if there's some other separate reason that you want to kind of call this thing out and have an additional documentation of it separate from your board meeting minutes. So I don't want anybody to panic around this discussion of recording decisions in your resolutions, because I don't think it's necessary for a lot of the routine sort of day-to-day business that boards do and the things that you vote on at many of your meetings.
Okay, next question. What can HOAs do to correct a hoarding situation? What are HOAs required to do? So this is really dependent on your governing documents. So the remedies available to an HOA under 6438 is vastly different from remedies available to communities under 6490 or the older condominium statutes. This is each hoarding situation, and I've dealt with quite a few in the 7-8 years I've been doing this. Each hoarding situation must be treated on a case-by-case basis on the information that you have. If the hoarding situation is not causing a problem other than belongings are piled up within the unit, there may not be any enforcement ability. You can still try to help the individual who is a hoarder, but you really have to balance the cost of dealing with this particular issue against the benefit of attempted enforcement. And also remember that you cannot enforce just based on the complaints of one owner. This really has to be a problem for multiple units or multiple lots. In dealing with hoarding, usually we try to start out with the least aggressive approach and then move on to more aggressive if that doesn't work. So least aggressive would be trying to contact any family members if neighbors or the board is aware of a family member of the individual involved in this situation. Neighbors, church contacts, any outside influence to bring this situation to their attention. Sometimes that works, sometimes it doesn't. If the informal outreach doesn't help, you can see if there are state and local agencies. Some counties have hoarding task forces, so there may be some relief there. If none of this works, then you're looking at and enforcing the procedures in your governing documents. And as I stated before, this is really a case-by-case basis. So contact your association attorney before you really get into this. One situation that happened in, oh geez, I think it was 2021 or 21-22. I think, Valerie, you were involved in this, but I'm not going to use the client name. We ultimately had to go through collections and foreclose against the owner for the damage done to the unit by the hoarding. So this was a condominium, not a HOA. So that's another massive difference. But improvement is going to take a lot of time. It will take a lot of board involvement. It's a very concrete step-by-step process. So
I'm going to jump in and add a couple of things, Jen. One is that I think it's important to remind folks that hoarding is a psychological disorder. And it's not somebody's just being a slob. It's not a choice that somebody makes to live in a particular way. It is a psychological disorder. And I think as such, number one, as just a good person kind of thing, you want to have compassion for somebody who is struggling with that disorder. And number two, from a legal and particularly disability related standpoint, you do want to be really careful. And I think it's worth repeating Jen's comment that you need to contact your association attorney to help walk you through the best approach to dealing with each particular situation, because you also don't want to take any action that could be viewed as discriminatory or as sort of targeting somebody with this psychological disorder, which could be viewed as a disability. So I think that's one thing to keep in mind. The other thing that I want to say is that the case that Jen mentioned, where we were able to address the hoarding situation indirectly because of a foreclosure lawsuit, was very unique because that owner was also not paying their assessments. Foreclosure is no longer available as a tool to deal with enforcement issues unless there is an assessment only balance due. And that is pursuant to legal changes that first took effect in 2021, but that were made even more stringent in 2023. So you can't foreclose unless there is at least $2,000 in assessments only that are unpaid. And you have to calculate that by adding up all of the assessments, subtracting all of the payments received, and you're not allowed to include or calculate that with any other types of charges. So fines are not included in that, late fees, interest charges, that kind of thing.
Repair costs.
Repair costs. So that was the other thing that I was going to say, is that part of why we do recommend this sort of least aggressive and only escalating as necessary approach is because very often if there are no family and friends that can step in and be of assistance, if you're not able to get the assistance of an agency, or if the owner refuses the assistance of an outside agency that you have successfully, gotten out to help with the situation, sometimes what you're left with is the litigation option, and it is slow and it is costly. And what it will result in essentially is a set of court orders that might authorize the association to go in and do a certain amount of cleanup and then charge those costs to the owner. But then you're left with the question of how you collect those fees from the owner. It's not always as straightforward as we wish that it was. And the other thing that I want to say is completely unrelated to all of that. One of the most common misconceptions that we hear from community associations when they understand that somebody, usually in a condo unit, is hoarding within their unit is like, oh, it's got to be like, it's a structural hazard because they have so much stuff piled up in their unit, it's going to like fall through the floor or whatever. And hoarding almost never rises to the level where the pounds per square inch are actually a structural hazard. So you can't rely on that in your enforcement approach with a hoarding owner. As Jennifer said, and I think it's worth reminding everybody, you're only able to enforce if the hoarding is resulting in some sort of nuisance or negative repercussions for the community outside of the unit. So if it's just too much crap in the unit and you don't like the way it looks, not a good enough reason to take enforcement action. It might be an excellent reason to try to get that person help because you have compassion for them and you want to try to connect them with resources for help, right? But it's not a reason where you're going to start finding the person or trying to take them to court over the fact that they've got newspapers piled up from 27 years in their unit. It's when you start to deal with things like smells, pests, or other issues that impact the units around them. That's when your ability to enforce really essentially gets triggered. So Jen, did you have anything else you wanted to add on that one before we keep moving?
Just briefly, what Valerie said about hoarding being a mental illness is so accurate. And just as with any other mental illness, unless the individual involved understands that it's a problem, they don't want help. They're willing to stay in their situation. So being mindful that this is one of your neighbors, this is a human, and treat them as you would want to be treated. But also, if you suspect that there's a hoarding problem, contact your attorney, contact the association's attorney, so you know what resources and steps are available instead of starting to try and enforce and then coming into a situation where nothing is working. Okay, let's call the attorney now, when there's all of this has already built up problems with that particular owner and a history that owner is going to have to now, owner or resident, I'm sorry, that owner is going to have to try and overcome to start moving forward in an appropriate manner.
Thanks,
That
Jen.
was it for me.
Okay, thanks, Jen. All right, I'm going to jump into our next question. Does Washington State require a homeowner directory be shared with owners? If so, does this apply to HOAs governed under 6438 and 6490? So that's the HOA Act and WUCIOA. So this is a relatively straightforward question and answer because all 4 of the common interest ownership statutes were amended in 2023 to include and sort of unify a records section that addresses this specific question. So I'm going to copy and paste into the chat the RCWs for, in order, the HOA Act, the old Condo Act, the new Condo Act, and WUCIOA that pertain to association records. And each of these contains a provision that requires an association to keep a list that includes all of the names, addresses, and voting percentages or number of votes allocated for all of the units or lots within each community. And there is authority under the record statutes that requires the association to distribute that list to owners upon request. And in fact, what it says is that owners are entitled to a free annual electronic copy of that list upon request from the association. So at least once a year for free, you have to give it to them. However, this is not absolute. There are things that must be redacted. So before disclosing the list to your owners, the association must, and I'm going to quote straight from the statute here, redact or otherwise remove the address of any unit owner or resident who is known to the association to be a participant in the address confidentiality program described in Chapter 40.24 RCW or any similar program established by law. So if you have an owner within your community that has notified you that they are part of some sort of address confidentiality program, you are required to redact their address from that owner roster list when you're disclosing it to anybody, including other members of the community. Another subset of information that you must redact is any unlisted phone numbers and unit owner email addresses. And this is one of the sort of single biggest pushback points that you're going to get from the ownership. Because if an owner is asking for a list of the owners, they almost certainly don't want to have to stick pieces of paper in the mail if they're trying to, like send out an email about some issue that they don't like the association's handling of, or if they're trying to campaign because they want to get elected to the board or whatever. They're going to want the email addresses. And the statute specifically requires that the association redact unlisted phone numbers and private email addresses for unit owners before sending that list out. So if the question is, does the association have to keep a list of owners, and what has to be on it, and what do they have to disclose to the membership? That's the answer. If the question is, hey, look, we've historically published a directory every year, we send it out to all the ownership. It includes not just the names and addresses, but phone numbers and email addresses. Is it okay that we keep doing that? My answer to that question would be, you should not disclose phone numbers or email addresses without the express permission of each owner that you're including that information for. And one of the things that I think is interesting and sort of displays a sort of how slow the law is to catch up to changing technology and whatever circumstances is the reference to unlisted telephone numbers, because I haven't seen a phone book in years, other than maybe I think we might have one in the office. I don't know. My parents live in a really small town and they have one at their house. So I don't even, is my phone number listed, unlisted? I have no idea. I would assume that most current cell phone numbers are considered unlisted. And I think that's a safe assumption for community associations to make. Any more specific advice on that particular point you would want to seek from your association attorney? Jen, did you want to add anything to that?
Just briefly, the association's required to keep a roster or list of all owners and then provide it to the owners as well. But owners' names and the addresses of the units are public record. So unless that individual is part of the address confidentiality program, you're pretty much fine in giving out public record information that can be found in other public records. But if you have any questions, contact your association attorney regarding a case-by-case situation. And then next question. Is an association required by law to carry insurance on their managing agent against crimes such as employee dishonesty, forgery, alteration, computer fraud, and general liability? So most declarations require associations to insure its own bank accounts, regardless of who steals the money. So if you insure your property, meaning the association's assets and bank accounts, the insurance company pays based on the loss to the asset, not who stole it. And then in most situations, the insurance company can then go after the thief. So, kind of taking a step back from that, statute is extremely sparse when it comes to insurance. So double check your governing documents. It's going to tell you what kind of insurance you need. Typically, most declarations required fidelity bonds for the board, fidelity bonds for a association agent, such as a manager, that sort of thing. So double check your governing documents. Make sure that the insurance that you have complies with what's in your governing documents. It's also just plain prudent business sense to ensure your assets and bank accounts, because honestly, it's so much better to have it and not need it than not have it and something happen, you need it, it's not there. We've had,
For example, I was teeing it up for you.
yeah, for example, over the past, I think 2 or 3 years, we have had at least 3 different clients have money either fraudulently withdrawn from their bank account through through an improper access. We've had one association have some sort of individual access invoices and provide fraudulent invoices. Actually, that was 2 different associations. But most of these situations are 100 grand plus when they're found. One that we're involved right now is over 500,000, and in that particular instance, it was a manager giving fraudulent invoices without proper checks and balances, and it was happening since 2015. So that particular situation is beyond rare, but it happens. If you don't have that insurance to protect the association, you're going to be out a lot of money and without any reasonable way to recoup that besides special assessing your owners. So next part of this question, can a managing company require this, meaning the crime insurance of the association? What if the association doesn't want to and wants it removed from the contract with the management company? So, as I said before, it's prudent business sense for the association to have insurance on your own accounts. So even removing the provision from the management contract doesn't change anything if this language is already in your declaration. Removing the provision will not require an obligation for the management company to have insurance for theft by its employees. So this is one particular instance where if you want your funds protected, you have to buy the insurance. And it's prudent business sense. We would strongly recommend it for all our clients to double check and make sure that you have this insurance. Also, it's typically required in most governing documents. Valerie, did you have anything to add?
Yeah, I mean, to the question about what if the association doesn't want to and wants it removed from the contract with the management company, that's a contract negotiation question, right? We routinely review management contracts for our clients when they're switching or hiring a new management company. And very rarely do we run into a management company that is, unwilling to negotiate on any term within their contract. That being said, part of what we view our job as is not just trying to get our board client whatever it is that they want. It's advising them on what we think is in the best interest of the association. And I think that's what Jennifer is trying to speak to, which is that sometimes this insurance cost is sort of the sticking point for the board. But if you talk the board through the risk that they're trying to insure against and the potential cost of not having that insurance, the cost benefit analysis becomes a lot more clear. And also, these are, as always, very general comments. You do have to look at your specific governing documents to determine what kind of coverage you are required to have. And you can't change that requirement by putting something into or taking something out of a management contract. All right, I'm going to move on to our last of the prepared questions for today, and then we'll jump into the questions from the chat. So this question is twofold. Can an association charge late fees on late fees? So if an owner is late in paying their assessments and they get charged a late fee, but then after the late fee is charged, they pay the assessment only, but they don't pay the late fee, can you keep charging late fees in the future? And also, can an association charge late fees when the only balance due is unpaid fines, enforcement fines? So as always, I'm going to remind you to check with your association attorney because we can't speak to any particular association in answering this question. And also, almost as always, I'm going to tell you that you have to start by looking to your declaration or your governing document. So what does your declaration say about your late fee authority? Some grant very broad authority about late fees, including language like, as an example, the assessments are due on the 1st of the month and late when not paid by the 1st, but the association has the authority to charge a late fee on any unpaid balance due on the 15th of the month or something like that. Others are much more narrowly written when it comes to late fees. Some will even cap the late fees at a specific dollar amount in the declaration. So you want to look at what your declaration says. And then you also need to look at your collection policy. If you have one, you want to make sure that it doesn't contradict the declaration, because the declaration trumps the collection policy. And then once you understand what your governing documents allow, that's when you hear Valerie's mom in the back of your head saying, just because you can doesn't mean you should, right? How many times have you guys heard me say that? Probably a lot. The purpose of late fees is to encourage owners to pay their assessments and to pay on time whenever possible, right? And if an owner is paying their assessments, even if they've paid them a little bit late, there is risk associated with levying late fees on a late fee only balance. So even if your documents say that you can do it, I'm not sure that I think you should do it. And so part of the question is, what is that risk? One piece of it is that if an owner challenges it in court, a court might, in hindsight, view the action of the association as unreasonable, right? Because you have to remember that a court is looking at these situations, 1, 2, 3, 5 years in the future, in hindsight, not substituting its judgment, trying to determine if the board action in a particular situation was reasonable. And so that's a hard thing to quantify when we are making these decisions as we go along. We recognize from a law firm perspective the risk of handling accounts that are composed entirely of penalties. And so we do a pretty specific, deep analysis of these accounts when they're referred to us. And sometimes we will decline to handle an account entirely based on that risk. Other times we will make a recommendation to the board, like if you waive all the penalties, we'll send a demand for the rest, or we will recommend to the client that they take a different approach than for a routine collections that would include assessments and other things, like maybe a small claims lawsuit or just a personal lawsuit, so that we can get a court to rubber stamp the reasonability of the balance due, as opposed to taking the risk of handling it like a regular collections matter. And one of the reasons for this is that we have learned that when owners challenge penalties like this, when they're filing a lawsuit or filing counterclaims in a lawsuit that was brought by the association, they never just make those claims against the association. They make the claims against the association, all the individual board members, the management company, the individual manager, sometimes even the law firm, and sometimes even the specific attorney or attorneys that were involved in handling the file. So while this is by no means a blanket or one size fits all evaluation, it's not something where we're like, we never handle accounts that look like XYZ. We do evaluate each account individually when determining whether we can help and how best to do so. And I think the same exact analysis applies when the principal balance due is fines only, with some nuances, of course. The fines themselves have to be reasonable. They also have to comply with state law and your governing documents in order to be enforceable. So you have to have a fine schedule that's been published to your ownership. You have to give due process in every single letter that you send purporting to fine the owner. And you have to actually follow your fine policy when you send out those fine notices. Assuming that your fine process is handled correctly, Many governing documents do authorize an association to assess late fees on balances due that are composed only of fines. And so that might be perfectly fine from a can we do this as we go along kind of perspective. Then the question after the fact becomes, how does your attorney help you if and when that account is referred to them for assistance in bringing it current? So there's some moving parts there, but I think one of the things I always want to remind my clients is fines are not intended to be an income stream for the association, and late fees are not intended to be an income stream for associations. Somebody asked in the chat about interest charges. Same thing, not intended to be an income stream for the association. And judges intensely dislike cases that come in front of them that are more about the penalties than they are about the underlying balances due. So I think you have to keep all of those things in mind. And that's what your attorney is keeping in mind when they are advising you on how to handle an account that's composed entirely of penalties. Jen, did you want to add anything to that before we jump into the questions in the chat?
No,
Okay.
I think I would like to take the question about L&I.
That's perfect. That's where I was going to start. So I'll read the
Okay.
question and then you run with it.
Okay.
Why should I, as a condominium representative who oversees our contracts, care about whether a company or contractor has an active account with Washington?
Oh, Valerie, you muted yourself.
Oh, so sorry. Why should I care if a company or contractor has an active account with L&I?
So just brass tacks, the only licensing for a contractor is through L&I, Labor and Industries. So if someone is not licensed through L&I, they are doing work that basically has no backing. It is an extreme risk to the association because there is no bond. There's probably no insurance. They are not licensed to work as a contractor in Washington state. So I own a single family home because God knows I'm not doing this outside of work hours, but anyone doing work in my house, I double check them through the state L&I website to make sure that they are licensed as a contractor and licensed to do the work that they're doing. One of our associations had a vendor doing work in units. This is a condominium, who was overdoing work. They were doing work that they were not licensed to do. They were not pulling permits. So the association had to go back and rip out everything that this vendor did and do it again with a licensed contracted vendor. So just on a risk analysis basis, any contractor should have a license through L&I. That license can change depending on what work is being done. Plumbers have to have a separate plumbing license. Electricians have to have a separate electrician license. And that's not even going into permits and making sure that work is being done properly. That's just, is this person authorized to do the work that you're hiring them to do? If they're not registered as a contractor through L&I, the answer is no. And they are too much of a risk to be doing work for the association. Valerie, did you have anything to add to that?
I think the only exception or sort of, footnote maybe that I would add is every job that you pay someone to do has a different risk profile in terms of the amount of money that you're paying, in terms of whether this is a big job that requires permits and special knowledge versus, if you're paying a handyman to come change light bulbs in the stairwells, right? And so it's not that there is never a scenario in which it's okay to use an unlicensed through L&I handyman person, vendor, whatever you want to call it, to do the work, but you need to understand the risk that you are taking when you do so. And any work that is substantial, either in the type of work that's being done or in the cost of the work, I think say you should never take that risk. That's our legal opinion from the perspective of trying to protect our clients. The next question that's in the chat is this: is there liability to the association if a chimney vendor was unable to access and provide inside cleaning versus just being able to assess them from the roof? The owners refused entry. I think the answer to this question is probably too specific for us to get into in this Q&A, because it depends, at least in part, on what obligation your documents impose on the association with respect to those inspections. Also, it depends a little bit on what your fire code, your local fire code might require in terms of those inspections. So this is a question that you're probably going to want to submit to your specific attorney. I don't know, Jen, if you have any general comments you want to add before we move on to the next one.
Honestly, this is a really case-by-case individual situation. If you want legal advice, you need to speak with your association attorney.
Okay, here's our next question. If a resolution format is chosen for a board policy action, would it be required or appropriate to incorporate it into or attach it to the board minutes, or to keep in a book of minutes or a book of resolutions? I would say yes to all of the above, that it would be appropriate. And I think the most important thing is that you as an association choose a method of tracking and retaining your policies, your resolutions, your documents as an association, and then stick with that approach so that your documents are easily accessible and, you know, maintained consistent with the state statutes on association records, etc. And the other thing that I would say is when your board resolution has to do with a policy that is going to be enforced against your ownership, it's equally important not just that you keep it in a certain manner with your documents, but also that you publish it to your homeowners. Jen, did you have anything you want to add on that one?
No.
Okay. Next question is, in the annual meeting, if the owners do not attend to establish quorum, how are board members then elected? You know, one thing I will offer is that we've covered this repeatedly over the last 3 to 4 weeks. So I don't think we should go into this in detail, Jen, but I think if you look at our last, say, 3 videos, you're going to get the answer to this question. And Jen, do you want to like recap really quickly so we can try to get to more questions?
Yeah, just briefly. So by statute, board members keep office until their successors are elected and basically seated. So if you do not meet quorum and are unable to hold a proper election, the board members continue. If a board member resigns or for some reason is no longer available to serve, the board has the authority to appoint individuals to fill that seat, even if there isn't a board quorum or there isn't an election. So the board continues, or the current board members can appoint other individuals to serve, but the board is still a board. And Ken has a story of a client where I think they went almost 10 years without a proper election because they could not meet quorum. But when that was challenged with a court, the board was able to point to board meeting minutes and show that they followed proper procedure for appointing and board members continuing until they decided to resign or whatever. And the board found that the actions taken, the court found that the actions taken by that board were proper, and that board was the board for that association. So just because you don't meet quorum doesn't mean that the board is suddenly acting outside of their, is no longer the board. There are provisions in place to make that work. It's just, you need to try and hold an annual meeting with quorum.
Yeah, and I will add to that, I do think that it's best that your board appoint successor board members at a board meeting where they have achieved quorum, meaning before you lose the person that's leaving, appoint their replacement, so that you're not trying to figure out whether you were like, did you have quorum as a board and therefore were your was your decision to appoint your replacement member valid, make sure you appoint the replacement member before you lose the person that's departing. That's just a practical suggestion.
If at all possible.
Yes.
There are some times when that isn't possible.
The
So
next question is related.
sorry.
I'm actually going to go into a related question, and because we've got like 4 or 5 more questions to try to get to here. Speaking of quorum, if quorum is not met in your first annual meeting, is quorum less for the second meeting if nothing is stated in the governing documents? And the answer to that question is no. There is no statutory provision in Washington state. Other states do have this. This is one of the things that we learned at the National Law Seminar this year. Other states are codifying this sort of step down in quorum requirements. If you fail to achieve quorum in the first annual meeting, then you can adjourn and hold your follow-up meeting within a certain number of days, and that will just by statute reduce your quorum requirement. But Washington state does not have a statute that allows this process. So we tell our clients, you have to look to your governing documents. Some governing documents do provide for this, many do not. And in that case, if your documents are silent, there isn't a statutory provision that allows you to automatically reduce quorum for a follow-up meeting. Did you want to add anything to that, Jen?
Just briefly, if you have a quorum that's 51% of all owners or some ridiculous amount like that, see what you can do to amend your bylaws. Typically, this is in the bylaws, not the declaration, to change your quorum requirement to what's in statute. Statute's either, I think, 25 or 34%, depending on which statute you're looking at. So if you have a ridiculous quorum requirement and you're never going to be able to make it, talk with your association attorney about amending your documents to make that more reasonable. Because of the changes in statute, you are now able to do a vote by mail procedure rather than having to hold a meeting and try and get quorum at the meeting, to enough people at the meeting to vote that in.
Yes, and I was just going to say one thing to keep in mind when you are having quorum issues is the fact that you can count proxies and absentee ballots towards your quorum requirement if you have followed the statutory provisions regarding those things when you're trying to achieve quorum for a particular vote. So I know some clients or people in the Zoom might even be sitting there thinking, well, great, we'll try to amend our documents with a quorum that we can't achieve to lower our quorum, right? But as Jen points out, because of the new voting procedures that are in all of the governing statutes now, you have a lot more options than you did before. I think we have time for maybe one more question. If a board has a board appointed secretary that is not a board member, can they stay during executive session to be available once the board goes back into the regular board meeting? So I'm going to take a stab at this, and then Jen can add her thoughts and comments to this as well. I think the first thing that I will say is that you need to make sure that your governing documents allow for a non-owner to hold an officer position, and even for a non-board member to hold an officer position. So that's one thing that I would want to check as a preliminary matter. If you have a secretary that is not a board member and you are adjourning from open session into executive session, then that person can just stay in the room that's not part of the executive session, right? They don't have to participate in the executive session in order to stick around and record decisions in the minutes once you come back into your open session. So executive session should be limited to elected board members and anyone else who's necessary for the subjects being discussed in executive session. So that would include, for example, your association attorney if you're involved in litigation or they're advising you on a particular issue, or perhaps contractors if you're doing a confidential bidding process. There are very few subsets of decisions and information that are appropriate to be discussed in executive session. And the last reminder that I would have is that you don't make actual decisions in the executive session. You discuss the topics at hand, and then you go back into your normal board meeting session, and that's when you vote and take action on those issues that you discussed in executive session. So if they're not a board member, then they don't participate in executive session, but they can just stick around and wait for you to be done. Jen, did you have anything you wanted to add to that one?
No. I think you've
all right. Well, we just got a whole bunch more questions right before the end. We're not going to get to them all, but I will try to remember. I'm going to try to snag them from the chat before we close out our Zoom account today. But if you put a question into the chat and we did not get to it today, please email it to info@condolaw.net and we will try to get to it next week when we are back here again at the same time, same place. Thanks for joining us, everybody. Bye.
Thank you.